Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner, and in this video, we are talking about the letters of experience and other key documentation required for I-140 petitions that are based on perm labor certification filings. There are three major things we have to establish with an I-140 petition based on a perm labor certification. One is we have to show that the employer or petitioner has the ability to pay. So we have to show documentation that they have the ability to pay the proffered wage, and we have a previous video on that. Second, we have to show that the employer has a position open to offer to the foreign national. That's typically just a letter from the employer. And third, we have to show that the foreign national beneficiary has all of the requirements, that they are able to document that they meet all of the requirements for the position. By that, I mean their education, their experience, any specific skills, and any licensure. So let's talk about how we document that. In terms of the experience required, that is typically documented by letters of experience, usually from previous employers. Sometimes in certain situations, we can use experience gained with the employer, but we have to be very careful and strategic about that. So typically this is letters from previous employers. Those letters must have a detailed job description. In addition, the letters need to specify the job title that the foreign national held and the specific dates that they worked in that particular position. If they worked in multiple positions, it's totally fine to list multiple positions and job duties in one letter as long as you specify those dates. In addition, if the foreign national obtained or used any specific skills or technology in that particular position, it's critical that that information is also listed in these letters of experience. The letters of experience need to be on company letterhead, and they need to be signed by either the HR professional or the manager or supervisor. It doesn't matter which one, as long as it's one of those professional classifications. The letters do not need to be original letters, but they do need to be signed. So it is acceptable to have a letter signed by hand with wedding signature, and then for that to be scanned and emailed to the immigration attorney putting together your case. So what if this experience letter is not available? It depends on why. So if the company has closed and that's why an experience letter is no longer available, a lot of times we can document that the company no longer exists, and then we can use affidavits from coworkers or colleagues that the foreign national worked with at the time. In other situations, there's really not an exception, and we do have to have those letters of experience. So it's critical that we make sure that you're able to get those, that the foreign national is able to get those early on in the perm process, rather than waiting until closer to the time of the I-140 filing and finding out you can't get them. Finally, other documentation that you'll need, of course, copies of your degrees and transcripts, also called mark sheets sometimes. If you have a foreign degree, a credentials evaluation showing that your degree is equivalent to a US degree is typically required. If there are any skills or technology that was not addressed or that were not addressed in the letters of experience, certifications showing that you have those, and of course, licensure. If your position is one that requires a professional license, for example, a vet, a teacher, a lawyer, things like that, counselor, those types of positions require licensure, and we have to show that you have that particular licensure or that you're eligible to obtain them. So I hope that you have found this information helpful. One final tip is it is critical that we make sure that the information and documentation that we present in connection with the I-140 petition is consistent across the board, not only across the I-140 petition and the perm labor certification that came before that, but that it's also consistent with anything else previously submitted to USCIS, whether that's an H-1B petition, an L petition, another non-immigrant visa application, perhaps a previous green card application. It needs to be consistent, because if USCIS finds inconsistencies, that can and will be a tremendous problem for the foreign national in question. So it's critical to make sure you submit the documentation that's required, make sure it is consistent with what has previously been submitted, and that you're not submitting documentation that doesn't actually need to be submitted. I hope that you found this information helpful. If so, please subscribe to this channel so that you don't miss our next video. Otherwise, my name is Emily Sumner with Sumner Immigration Law. We assist clients, both employers, employees, and individuals and families with employment-based and immigration matters across the United States and around the world. Until next time, my name is Emily Sumner.